Senators Chuck Grassley, Thom Tillis, Cornyn and Ben Sasse, members of the Senate Judiciary Committee, introduced legislation on February 13, 2019 requiring disclosure of third-party litigation financing agreements in civil lawsuits. Based on agreements, hedge funds and other commercial lenders finance the cost of civil litigation in return for a share of any recovery. Yet the presence and terms of such agreements are seldom disclosed to the court or opposing parties. Transparency brings accountability. It's true for Congress, the executive and our courts. For too long, obscure third-party litigation funding arrangements have secretly funneled money into our civil justice system, without any meaningful oversight, all for the purpose of profiting off someone else's case. We should know whether there are undue pressures at play that could needlessly prolong litigation or harm the interests of the claimants themselves. A healthy dose of transparency is needed to ensure that profiteers aren't distorting our civil justice system for their own benefit. Our bill strikes the appropriate balance in getting certain information out in the open while allowing courts to craft necessary protections, Grassley said. The Litigation Funding Transparency Act is common-sense legislation that will shed light on third-party litigation financing agreements to ensure that the court and opposing parties are made aware of who is financing the litigation and whether or not there are any conflicts of interest, Senator Tillis said. Americans deserve a transparent and fair justice system that ensures third parties can't anonymously pump millions into litigation. This bill will shed light on where this money is coming from and keep the civil justice system honorable and fair, Cornyn said. A court's ruling should be about laws and the facts, not about the size of your bank account. By shedding light on funding arrangements, this legislation is a common-sense step toward making transparency the rule, Sasse said. The Litigation Funding Transparency Act of 2019 provides a simple, even rule that would apply to all class actions and multi-district litigation (MDL) proceedings in federal courts. In any class action, class counsel shall disclose in writing to the court and all other named parties to the class action the identity of any commercial enterprise, other than a class member or class counsel of record, that has a right to receive payment that is contingent on the receipt of monetary relief in the class action by settlement, judgment, or otherwise.